Howdy, my name's Brian Foley. I'm a criminal defense lawyer here in Conroe, Texas, and I represent folks who've been accused of a crime in Conroe, the Woodlands, Houston, and that general area. Today we're continuing our short lecture series on the Texas Rules of Evidence. Today's rule is Rule 203, and today's rule is going to be a quick one. Today's rule is about foreign law. How do you deal with foreign law in entering in that law into evidence? Well, 203 explains the notice requirements for relying on foreign law. And it just says that you have to give notice of at least 30 days in advance, which is deemed to be reasonable notice. And then if the law in question is in a foreign language, you need to convert it to the language that's being used by the court, which is going to be English. Okay? So in general, this rule is almost never used. The only case I can think of where it's even an issue is Medellin versus Texas. It is 552 U.S. 491, Supreme Court of the United States. And that is a case where he was a death row inmate in Texas, and he argued that the Vienna Convention prohibited Texas from carrying out the order of his death sentence. And the Supreme Court of the United States ruled that the Vienna Convention and then President Bush's decision to abide by its terms were not binding at all on the state of Texas. And so, in that in that litigation, this rule 203 could have been used, and it likely was. But here's an interesting quote from that case. This again from Medellin versus Texas. Nothing in the text, background, negotiating, and drafting history or practice among signatory nations suggests that the president or the Senate intended the improbable result of giving the judgments of an international tribunal a higher status than that employed by many of our most fundamental constitutional protections. So, great. If your lawyer is interested in arguing foreign law for you under Rule 203, maybe you got the best lawyer ever, but maybe they don't know what they're doing because the Supreme Court says it doesn't really matter. It could be maybe if you had like a jurisdictional issue in Texas near the border, you could bring something up. But man, if I'm your lawyer, we're not going to be arguing Rule 203 unless there's some really strange circumstances to your case. So I hope you've enjoyed today's installation of the Texas Rule of Evidence lecture series, but I doubt you will ever use it. But thanks for listening.